Hi there, I'm Charlotte, and I'm here today to talk about the similarities and differences between IDIA and 504. Both the Individuals with Disability Education Act and Section 504 of the Rehabilitation Act of 1973 are laws that represent attempts to improve conditions of those with disabilities. Both of these laws protect people with disabilities. And both of these laws allow for FAPE, which is free and appropriate public education, which had ended the previous separate but equal mentality that led to institutionalization. IDEA and Section 504 provide procedural safeguards as well as evaluation and placement procedures, and both allow for due process. IDEA is a special education law, and 504 is a civil rights law. Those are two significant differences. In order to qualify for IDEA, you need to have one of 13 disabilities and evidence to show that there's an adverse impact to your education due to this disability. For a 504 plan, a child does need to have a disability that is getting in the way of his or her own learning in a general education setting. They need accommodations, but not specialized instruction as you would under IDEA. IDEA provides individual supplemental education services and supports, in addition to what is provided to students in the general curriculum, to ensure that the student has access to it and to benefit from general curriculum, and it is all free to the parents. Under 504, it requires schools to eliminate barriers that would prevent students from participating fully in programs and services offered in the general curriculum setting. In regards to delivering services, under IDEA, it requires a written individual education plan, an IEP, which has specific content addressing the disability, the specific educational services that must be delivered, mandating a transition plan for the student once they turn 16 years or older, as well as any behavior intervention plans for a child with a disability that has a behavioral issue. Appropriate education is defined as a program that's reasonably calculated to provide educational benefit to a student. Relating services are provided as required for the student to benefit from these educational process and that are aligned with the specifically designed instruction. So those specialized services would be occupational therapy, speech therapy, physical therapy, etc. A 504 does not require a written IEP, but it does require a documented plan. The documented plan accounts for reasonable accommodations that must be made for the child with the disability, and it requires the schools to provide reasonable accommodations and supports that allow this child to participate in the general curriculum. Their definition for an appropriate education is as comparable to one provided to the general education students. Under IDEA, it provides additional funding to states and local school districts to help cover the excessive cost of providing special education to eligible students. A 504 does not provide extra funding. Under IDEA, a full evaluation is required every 3 years, using a variety of assessment tools and strategies to gather relevant functional and developmental information that's provided by a parent and the team in order to help determine what the child's disability is and how it affects their educational program. Multiple assessment tools are used in order to assess the child in all areas of the suspected disability. Written consent is necessary by a parent or a guardian in addition to before the initial evaluation. We are required to do reevals every 3 years by the IEP team to determine if the services are still needed to address the student's disability. 504 does not require the 3-year evals that an IEP does. Their evaluations draw on information that come from a variety of sources. A group decisions made based off of the person's knowledge of the student, the evaluation data, and the available educational placement options. Written consent is not always necessary before completing an evaluation, but the parents or guardians must be notified. This does require a yearly reeval. Some of the differences under the procedural safeguards are that under IDEA, you are required to give written notice to the parent or guardian prior to the evaluations or the placement of the children. Changes in services or placements must be given in written notice before the legal change can take place. A 504 doesn't require the written notice going to the parents or to the guardians, but it does require notice before a significant change in placement occurs. There's a lot of differences between 504s and IDEA. Under public schools, I have gotten the luxury of working with IDEA firsthand and servicing children with IEPs, as well as with 504s. And the differences between the modifications and accommodations are visible, as well as are legally documented. I hope that this is some information that you were able to learn something from, and I surely learned a lot by researching this stuff. All right, I will see you guys soon. Bye.